Hello and welcome to today's webinar. Today we are talking about contentious estates in BC. We have our amazing guests who I'll introduce in just a minute, Emily Davies and Erin Pearl, who are both lawyers at Clark Wilson in Vancouver. My name is Paula Price. I'm with the People's Law School and I will be your host and moderator today. We are talking about contentious estate matters in British Columbia, and the topics we'll be covering are concerns about executors fulfilling their duties, disagreements among beneficiaries, and wills variation challenges. Now, what you can expect today, we've got about 60 minutes together, and our guests will be providing answers to common questions. They will be providing legal information, not advice that is current as of today. So if what you're looking for is legal advice, in other words, the law as it applies to your unique set of circumstances, we would invite you to reach out to a lawyer. You are welcome to reach out to either of our guests. Their contact information is on the screen. We would like to acknowledge that we, the People's Law School team, we are grateful to work on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh Nations, whose peoples continue to live on and care for these lands. And we invite everybody who has joined us to reflect upon where it is that they are joining us from today. We would like to thank our funders, the Department of Justice Canada, the Law Foundation of British Columbia, and the Notary Foundation of BC, whose financial support makes it possible for us to produce these webinars for you. And finally, we would love to thank and acknowledge our speakers, Erin Pearl and Emily Davies. Erin is a lawyer with Clark Wilson in Vancouver, British Columbia. He practices in estates and trusts and elder law, and his practice includes helping his clients navigate the challenges of estate litigation, which, as you can expect, can be highly emotional. He regularly appears in court in British Columbia on a wide variety of contentious estate matters, including issues that we'll be discussing today. Erin is a credentialed practitioner with the Society of Trust and Estate Practitioners, also known as STEP, having gone through the rigorous training that is required to earn that designation. Welcome, Erin.
Thank you. Thanks for having me.
We're thrilled to have you. Thank you for joining us. We also have Emily Davies with us here today. Emily is also a lawyer with Clark Wilson in Vancouver. She practices in estates and trusts, and Emily helps her clients achieve peace of mind, knowing that their legal affairs will be handled as they work through the difficult process of litigating over a loved one's estate or trust. Emily, we are thrilled to have you here today. Welcome.
Thank you.
Thank you. So with that, we're going to dive into the questions that we have prepared today. And the first question is for you, Erin. I thought my grandma left me money in her will, but I haven't heard anything. I asked my uncle, the executor of her will, but he hasn't responded. How would I know if my grandma left me anything? Where can I get a copy of the will?
All right, this is a good question, and a lot of estate issues start right here with just getting a copy of the will. It's interesting that this person doesn't have a copy of the will, but they do know who the executor is, because of course, the first step, just practical wise, is trying to reach out to the executor. So having a lawyer reach out can be a good option. But if that doesn't work out, which looks like is the case here, one thing to do is there is a wills registry. It's in Victoria. Not every will is registered there, but it's quite common if there's a lawyer that created the will, and again, you don't always need a lawyer to create a will. A lawyer will register the will there so that there's a record of it. Now, if you apply, and you can even apply while the person is alive, if you apply to the wills registry to see if they have a record, you're not going to get a copy of the will. You're going to get a document that shows the information they have, which will show, I believe, the date of the will, and it'll also show where the will is kept. So a lot of the times it'll be a lawyer's office that will be shown there as being where the will is kept, and then you can then proceed that way with either contacting them yourself or having a lawyer do it for you. If all of that fails, there actually is a pretty straightforward, I should say relatively straightforward process for obtaining a copy of the will. And it certainly helps, of course, if you know who the executor is, or if you know where the will is kept. It's called a subpoena, which is a word a lot of people are familiar with because people are subpoenaed to give evidence sometimes. But a subpoena can specifically be used just to compel someone, if they have a copy of a testamentary document, which is a will, to bring it forth to the court registry where it would then be available to you. In order to get a subpoena, there is some evidence required, but you don't actually need to go to court, which is good. You just need to requisition it from the court. So it's a brief affidavit. You would need to show that you made a request to whoever it happened to be, the executor, et cetera, and that you didn't get a response or whatever the case is. And so I've used subpoenas in the past where we can't get a will. Of course, it's a lawyer could help out with getting a subpoena, but it is the kind of thing that is simple enough that maybe you could do it even without a lawyer.
Super. Excellent. Thank you, Aaron.
Yeah, of course.
This next question is for Emily. Emily, my father died 2 years ago. My stepmother is the executor of his will. She ignores my request for financial information and so far hasn't distributed any funds. What can I do?
Yes, so again, this is a pretty common question. And yes, 2 years is a long time without any information or any funds. And so there are a few options that you could take here. The first being the least costly and sort of the fastest action you can take. You can either get a lawyer to help you do this, or you can try to do it yourself, but is to write a letter to the executor. If you find that your attempts yourself are not working in getting more information or funds, if that's not going anywhere, then you might be useful to get a lawyer to do so. Just to indicate that you're sort of taking steps to increase the seriousness of the situation. A lawyer's letter will not guarantee a response. It will not guarantee you answers, but it could encourage a response from the executor, as it is sometimes persuasive that way. If that doesn't work and you don't get the information that you are hoping for or the funds that you are hoping for, you or your lawyer can also file many different applications with the BC Supreme Court to force the executor to either provide you with information or funds, or to force them to move along the estate. If what you're looking for is more information, generally an executor does have the duty to those that have a beneficial interest in an estate. And so due to this, you can bring an application for the executor to formally pass their accounts. And this requires the executor to present an accounting or all of the records regarding the money that goes in and out of the estates since they became an executor. So that can help you get some financial information and some sort of peace of mind as to what the estate is doing at this current time. Regarding the distribution of funds, you can request an interim distribution, which is sort of like an advance on your inheritance before the estate is completely wrapped up. And this would be a portion of your inheritance. It's not like it's extra money. And if the executor is refusing to do this or ignores your requests for this type of interim distribution, then you can file an application for that as well. And how much you can get sort of depends on what has to be done with the estate and how much money that will take the executor to do so, because obviously they cannot give you money if it needs to be used for estate fees. So that's another option in terms of getting some money from the estate. And if you are still feeling dissatisfied with the actions that the executor has taken in their role as executor, you also have the option to apply to remove the executor and replace them with someone more appropriate. That could be another beneficiary, it could be yourself, it could be a lawyer, a trust company, many options, depending on sort of how onerous the estate is. Under these, by doing this option, the executor can be removed and replaced if, for example, they are not responsive, if they're unwilling, unable, or unreasonably refusing to carry out the duties of being an executor. And there are sort of many factual things that will be taken into account in determining if they really have failed as in their duty as being an executor. So that's something that it could be useful to have a lawyer help you with. So all this to say is that you have many options if you are dissatisfied with the executor's actions as executor. And so just to summarize, you can write a letter, or there's various types of applications that you can make.
Super. Thank you so much, Emily.
And
Emily,
just to add, those applications, sorry, Paula, those applications like the one for an interim distribution or for removal of executor, those are a high bar, and they're those I would consider complex applications. But as Emily covered, those do give you some options.
excellent. Thank you so much, Erin. Emily, this next question is for you. My sister is the executor and only other beneficiary, along with me, of our mother's estate. She wants compensation for her work as the executor. Is that allowed? And if so, would she be compensated as an executor or as a beneficiary? Do I have a say in how much she gets paid?
Yes, so just to start with the first question, is compensation as an executor allowed? Yes, it is allowed, and it is quite typical for an executor to receive compensation or remuneration for their work as an executor. And this would be compensation as an executor. It would be separate and in addition to what they receive as a beneficiary. It's sort of easiest to think about this as as your sister wearing two hats in this estate, one as the executor, for which she would receive remuneration or compensation, and then the other as a beneficiary, where she would receive her inheritance completely separate. So there are sort of two categories of remuneration that an executor can receive, and if you did want to look into this more, it's spoken about at Section 88 of the Trustee Act. The first of these two categories is a fair and reasonable allowance of up to 5% of the gross aggregate value of the estate. So that includes the assets that were present at the deceased death, as well as any income generated by the estate during the administration. So, for example, if investments gain value since the death of the deceased. And sort of this 5% goes to the care, pains, and trouble that the executor had to take in order to be executor. In addition to this, the executor can also receive an annual care and management fee of up to 0.4% of the average market value of the assets. So for example, if the executor manages estate assets of $500,000 in a year, they could make up to $2,000 in that year. So both this 5% and 0.5% are maximum amounts in the respective categories, and they are not automatically awarded to an executor. The amount given to the executor depends on these various factors. So for example, the size of the estate, the complexity of the estate, how much time it has taken the executor to sort of fulfill the duties as the executor, among others. And it's kind of helpful to remember that the whole point of providing executors with remuneration is to encourage people to continue to be executors. They obviously provide a useful service to the beneficiaries and to make sure that estates are taken care of. And if any of you have been executors, you know how time-consuming and stressful it can be. So that's sort of why there is this monetary component. And then just to wrap up the question, do you have a say in the remuneration? So sometimes the remuneration amount is set out in the will, and it will sort of be in reference to the percentages or bulk amount. And if it's not set out in the will, then the beneficiary and the executors can agree on it, so you would have a say there. And if there is no agreement between the parties, then sometimes it does have to go to court in order to determine how much remuneration is appropriate in the circumstances. And just to sort of tie this up, sorry, I've been talking for a while.
Great, thank you.
But if you are concerned about the executor paying themselves remuneration, before their job is complete or before you have consented to the amount of remuneration, you best be assured that that's not allowed. That is called pre-taking of remuneration, and it is not allowed in BC. So in order to pre-take remuneration, the executor would need the consent of the beneficiaries or of the court. So you don't need to worry about them paying themselves before you were aware of it or before you consent to it, just because they have access to the accounts.
Super. That's really helpful. Thank you so much, Emily. Erin, this next question is for you. I think the executor of my mother's estate failed to deal with estate property that is held within a trust. How long do I have to start litigation against the executor?
Yeah, so there's a couple parts of this question that stick out to me that as a lawyer, I would really need to know more to give a perfect answer. And that is the failed to deal with. What does failed to deal with really mean? And also the I think this happened part is actually quite important to the answer because so just generally speaking in BC, the limitation period for bringing an action after you discover that something has happened that has caused you some sort of damage, as we call it, is 2 years. So if you think that there's been a breach of trust of some kind, it is highly recommended that the action is brought against the executor within 2 years. Now, in terms of, there's some other types of applications that this 2-year limitation period wouldn't necessarily apply. So when you say, how long do I have to start litigation? Well, there's other things. I mean, a removal of an executor doesn't necessarily have a 2-year limitation period. Same with an application for them to pass accounts, like Emily was talking about, wouldn't have a 2-year limitation period. And so an application to pass accounts is actually, like Emily was saying, is a way that you could certainly find out some more details about what happened within this trust, because that should show you everything that came into the trust and everything that went out of the trust. And so, in terms of failed to deal with, well, you'll see there in the accounting, which can be sometimes a bit complex and confusing to look at, even for lawyers who look at a lot of them, because it's just scattered numbers sometimes and they're not that organized. But you will be able to try to identify, well, was this part of the estate property dealt with or not? So an accounting could be a good first step to go from I think to, okay, I know that something has been dealt with improperly. But generally 2 years from when you find out to be safe is what we always recommend.
Super. Thank you, Erin. Another question for you, Erin. I'm both the executor and the beneficiary of my deceased mother's estate. I want to make interim and final distributions to the beneficiaries, my siblings, and me. My siblings have threatened to challenge the estate. How can I safeguard any distributions made?
Yeah, thank you. So there's 2 things here. There's an interim distribution being contemplated, and there's a final distribution. So let's start by talking about an interim distribution. An interim distribution is basically anything that isn't a final distribution. A final distribution is the estate is over, this is the end, here's the last of your inheritance. But an interim distribution, there can be one or several that happen before then, like Emily was talking about. It's helpful if the executor agrees, of course, but these are amounts distributed out, and the executor will want to hold back some, we call it a holdback, actually. They'll want to hold back a sum of money that they think is going to be enough to cover liabilities. And so you'll get accountant's advice on what might be the tax liability. You'll talk to a lawyer about what might be remaining in legal fees. And then there might be some other things that you know about that are outstanding liabilities, whatever they might be. So that's a consideration, of course, in terms of making an interim distribution. Now, talking about this threaten to challenge the estate and safeguarding distributions, when we say threaten to challenge the estate, it sounds like, and this is coming from, someone who's the executor, it sounds like they're threatening, the siblings are threatening to say, executor, you didn't handle something properly within this estate. That's what it sounds like they're doing when they say challenge. And so in that case, yes, you would want to safeguard your distribution. Firstly, that threat, whatever it might be, is going to have a significant impact when you go to talk to a lawyer about what should I hold back for legal fees. If it was me, I would be saying, well, if you have a threat of litigation about what happened within this estate, then you're going to want a significant holdback for legal fees, because legal fees for litigation can be significant, and you don't want to be caught paying it out of your own pocket. You want to make sure you have enough in the estate to cover whatever this threat might be. So what can you do to safeguard this? Well, there's a few things I want to talk about here. In terms of releasing yourself as executor of claims, you really only have two options. One is having the beneficiaries sign a release, which says we are content with the administration up to X date, whatever it is, the date of that interim distribution. And so they're signing that they're not going to bring any claims up to that point. That happens quite a bit. It's pretty common. But in this case, I don't know if that's going to happen because the siblings have been threatening something. And if they're threatening something and they're not going to sign a release, then the only option is to go to court to actually pass your accounts as executor. What passing accounts really means in layperson's terms is it's a release from the court. It's an approval of the accounting, your management of the estate up to a certain date, so that and when you go to seek that approval, you'll have to serve the beneficiaries so they have notice of it, so that they can raise whatever objections they might have. But if the court passes the accounts, that's like a release. The court is approving what you've done up to that point, and you are going to be safe in terms of any litigation regarding your administration up to that point, and you can make an interim distribution, of course, with reasonable holdbacks. The one other thing I would note is that whenever a distribution is made, we'll often add an indemnity. And there is a case that's called the Contentious estate from a couple of years ago, where the court specifically said it's appropriate for an executor to get an indemnity from beneficiaries when making an interim distribution, or even when making a final distribution. The indemnity says, well, I'm giving this money out as an executor, but if there are liabilities that go over and above what is left in the estate, then the beneficiaries will cover it from their share. Now, it's not ideal, because if that does happen, it leaves you in a situation where you're chasing these beneficiaries for money that you gave them, and that money certainly could be gone. But that is something that is an appropriate step to add some safeguard when a distribution is made.
Excellent. Thank you so much, Aaron. Another question for you, Aaron. As the executor, how do you deal with beneficiaries who refuse to sign a release for interim or final distributions? Can I distribute the estate assets without their consent?
Yeah, and the reason I'm covering these two questions is they kind of blend into each other. So as I was just saying, if there is a refusal to sign a release, and that's totally appropriate for a beneficiary, if you are a beneficiary in this case, to refuse to sign a release because maybe you have some questions or some objections with what the executor has done up to that point. your option as executor is going to be to pass accounts. And then what often will happen is you get into this push and pull between executor and beneficiary of, look, it's going to be so expensive for me to go to court to pass the accounts, just sign the release. But the beneficiary doesn't want to sign the release because they have issues. And it ends up going in many different ways, sometimes settling, sometimes court, sometimes the release is just signed. You never know. So that's how you deal with it, is you basically say, if you don't sign a release, I have to go to court to pass my accounts. Having said that, there is law that talks about an executor cannot hold the inheritance hostage, basically, in return to negotiate a release. So even if you're going to pass accounts, you can still be compelled to make an interim distribution, but with a holdback that is sufficient to for legal fees or whatever else there might be to pass your accounts. Can I distribute estate assets without consent? Yeah, you can. You don't need someone to say that it's okay for you to give them money. You can cut a check and say it's available for you, or send it to them, or whatever the agreement might be, but you don't need them to actually agree for you to distribute money. It's, as executor, you're obligated to advance the administration of the estate, and you don't have to wait for consent. You do have to wait for consent for a release, for an indemnity, for things like that, but not necessarily to distribute money once you've taken care of all those other things.
Super. Thanks, Aaron.
Sure.
So moving on to the next question. Can my mother disinherit me by putting all her assets in a trust? If she did, what options would I have?
All right, this is a really good question, and I'm sure it can be on a lot of people's minds. We're moving now to wills variation claims. The short answer to this question is actually yes. BC has this system. I actually started as a lawyer in Ontario, which is very different. There is not wills variation in Ontario the same way there is here. So I have seen how a different system works. BC has a system where there's wills variation claims, and we can talk a little bit more about what that is. I think Emily will talk about that. But there are legitimate estate planning strategies to get around someone bringing a wills variation claim. And one of those strategies is putting funds into a trust, because a trust is not considered, funds in a trust are not considered part of the estate, and a wills variation can only apply to funds that are, or assets that are, part of an estate. So when trust funds, money that comes from a life insurance policy, funds that are subject to a beneficiary designation, funds that are held in joint tenancy, or a property for that matter that's held in joint tenancy, these things are outside of an estate and will not necessarily be accessible through a wills variation claim. There are options in these cases, and the options are really going to vary depending on the circumstances. Just to go into them really briefly, there's potential claims that the trust was not made legitimately. There's also potential claims that money was put out of the estate fraudulently to avoid some type of legal claim against the deceased. However, that legal claim cannot be a wills variation claim. So it is legitimate to move money out of your estate to avoid a wills variation claim, but you can't move it out of your estate to avoid some other claim, like a debt claim, or any other claim you might be able to imagine. So those are generally some options if there is money in trust, but it is a legitimate estate planning strategy.
My grandmother left me out of her will. Do I have the right to challenge it?
Yeah, so challenging a will can mean many things. As Aaron has just discussed, wills variation. I'll discuss if to mean when you say challenge a will, I'll discuss whether that means will's variation or otherwise. So, for example, challenging a will can also mean questioning its validity due to things like undue influence or capacity of the will maker. In regard to a will's variation claim, only spouses and children have the ability to make these claims. So as a grandchild, you would not be able to apply to vary the will. And Section 60 of the Wills, Estate and Succession Act sort of speaks to that. I saw one of the questions was what are the relevant statutes that apply to these sections? And the Wills, Estates and Succession Act is one of the major ones. But we can sort of talk to that later. And I mentioned validity challenges are also a form of challenges. And that's, like I said, is about undue influence or capacity. And in that sense, as a grandchild, you would have the ability to challenge the will. Anyone who is a descendant of the deceased can make a claim like this. So that's sort of like lineal descendants, depending on your bloodline of being related to the deceased.
The next question, if I sign off on a distribution under my mother's life insurance policy, will I lose my right to challenge her will?
Yeah, this is an interesting question. The answer just off the top generally is going to be no. There shouldn't be a connection to you getting life insurance proceeds and challenging the will, whether it's a actual challenge to the validity or a will's variation claim. I will say that in a will's variation claim, we were just talking about how funds that are outside of the estate, which would include insurance proceeds, are not accessible through the will's variation claim. But there is also law that things like this, like life insurance proceeds, are going to be taken into consideration when a judge is looking at how to decide a will's variation claim. Okay, so in other words, there's let's say $1 million in the estate. You are a child, you didn't get anything, and your siblings got all of it, but you also got $500,000 through a life insurance policy. If you bring a will's variation claim, yes, that $500,000, that life insurance proceeds, is not going to be part of what can be varied by the judge, but the judge is going to say, well, you did get this other money, and so that is taken into account in terms of what you should be entitled to when varying the will. And in terms of actually challenging a will based on capacity or invalidity, there should not be any issue with accepting a life insurance proceeds and proceeding with that. The only one thing I would watch out for that came to mind is that you might have some explaining to do if you have a life insurance beneficiary designation that was made maybe around the same time as a will. You accept the life insurance proceeds, but you say the will is invalid because the deceased will maker did not have capacity to make it. Well, you accepted this even though they might not have had capacity, but you don't accept this on the other hand. Just something to watch out for. I always try to think about, making sure you're clear on all bases there.
Excellent. Thank you so much, Aaron.
Sure.
This next question is for you, Aaron. My common law spouse and I have lived together for 10 years. In a will he made before we met and never updated, he left everything to his kids. We lived in a house that he owned and pooled our resources for furniture and other household items. I don't want to lose everything and end up without a home or furniture. What can I do?
All right. So this does come up a fair bit. And there's a lot more facts here that are going to need to be understood in order to know how to proceed. Generally speaking, so first of all, off the top, in BC, marriage does not revoke a will. And I recognize that this question is specifically about common law spouse. So obviously, of course, a entering a common law relationship would not revoke a will. But also, if there was a legal marriage, in the past that has caused a revocation of wills in BC, but that is not the case. So what that means is you are going to be left dealing with a will, even though you're in a kind of a late stage relationship with someone. You might be left, if they don't update their will, you're going to be left dealing with that will as it is. Since you're a common law spouse, you would have a wills variation claim. And in that wills variation claim, you would have a pretty strong case to perhaps keep the house, or to at least keep the house for a period of time, and until you pass. Sometimes that's called a life estate or a life interest. In terms of furniture and other household items, I see in this question it says you pooled resources to collect those items. And so I think that there's going to be here a pretty strong argument that those items don't necessarily belong to the deceased. It looks like they belong to both of you, perhaps jointly, since you pooled your resources to get them. And so they're jointly owned, and they would go to you by survivorship because you survived the other joint owner. And there shouldn't be an issue. Now, by all means, the children of your common law spouse might make an argument. I see this most commonly when we're talking about household items. I see this most commonly with art that has some value, because it can be a little ambiguous who owns it. Even maybe sometimes one person bought it, but then they shared it over time and it was part of the house. With furniture, there's not typically that much argument, but there certainly can be. One other thing that I did want to mention, if you're a spouse, there are provisions in the Wills, Estate, Succession Act that allow you to acquire the spousal home. I don't have the section off the top. It's around section 26 and onward, 26 to 35. I'm just looking at my screen here. These are not often used, and why they're not often used is because it actually involves if spouses live in a house together, and the spouse, let's say, the house is owned by one spouse and they die, which is the situation in this case. That second spouse should not be just left on the street, so they can acquire, which actually means purchase, the home. So you have that opportunity. It's not ideal because you're not just left the home, you're actually having to purchase it. I've personally only actually had this come into play once, and so it's not often used, because you would typically want to try wills variation to see if the court finds that it's just for you to just get the house outright. But it is an important section of the Wills, Estate, Succession Act to know of, because as a spouse, you can be entitled to acquire that property.
Excellent. Thank you so much, Aaron. Emily, this next question is for you. And the question here is, my husband died last month and he left me with nothing. Can I contest his will if I signed a prenup?
Sure. So a prenup can be sort of like a marriage agreement or a cohabitation agreement. So that refers to common law spouses as well. And they can exist even if you aren't formally married. So looking at the terms of your prenup agreement here is important. So for example, the prenup may not even speak to wills variation claims at all. And so there's no reason why that should impact your wills variation claim or your ability to bring one. But if the prenup does say that you are not going to bring a wills variation claim, it still will not necessarily prevent you from bringing a wills variation claim. However, it could be considered in the court's decision about how much to vary the will or if it's appropriate. So as you've gathered from Aaron's answers previously, wills variation claims are very fact-specific, and it's about balancing the deceased's intentions and their moral and legal obligations owed to their spouses and children. So while if a prenup states that you would not bring a wills variation claim, that would indicate the deceased contemplated that, number one, a wills variation claim could be brought, and they still left you with nothing. So that would be pretty strong evidence about their intentions regarding their estate planning and that they intended to leave you nothing. However, this evidence would be weighed against other factors of your relationship or your financial need, various things like that, as well as their legal and moral obligations owed to you. So all that to say, it could impact your strength in a wills variation claim, but it would not be able to prevent you completely from attempting to bring such a claim.
Excellent. Thank you, Emily. And we've got just a few more questions before we turn to the live questions. So maybe we'll move through these ones a little quickly so that we can see what questions have come in from our guests. So, Aaron, this question is for you. There's a no contest clause in my mother's will. If I challenge the will, do I risk losing the small amount she left me?
I'll be quick. No, these types of no contest clauses are void in BC. There's a couple cases about that. So no, it shouldn't be. You might want to talk to a lawyer about it because it can be a little off-putting to see a clause like that and know whether you can proceed. But generally, no, you can still proceed with a wills variation claim, and certainly a will challenge, a challenge to the validity as well, because, well, if the will isn't valid, then the no contest clause isn't valid either.
Super. Thank you so much, Aaron. Emily, this next question is for you. My father brought a claim to vary his mother's will. He died before the litigation was resolved. Do my siblings and I have the right to continue pursuing the claim on his behalf?
So as your father's child, you do not have like a broad right to continue the litigation. However, litigation can be continued on behalf of someone's estate by the executor of the estate. This is spoken to in Section 150 of the Wills, Estate, and Succession Act. If you or your siblings are the stated executor, then you would be able to continue the litigation against your mother's estate. However, if your father did not have a will, you or your siblings would have to apply to the court to be named as the litigation guardian. And this is in the Supreme Court Civil Rules, which is different from the legislation I was referring to earlier. And that's at Rule 20-6. And that sort of is someone acting on behalf of the estate in litigation if it involves the deceased estate. And yeah, so yes, you can continue the litigation.
Excellent. Thank you so much, Emily. And then this is our last question before we turn to the live questions. I want to challenge my father's will. The main estate asset is a house that he owned. Can I put a lien on the house to protect my interest until the litigation is finished?
Sure. So I'll try to be quick with this question. It is a little bit, it can be kind of complicated depending on the facts and the situation. So again, it may be helpful to talk to a lawyer about this one. So generally during litigation, if property is involved, a certificate of pending litigation can be put on the title of the property, which is also referred to as a CPL. And a CPL will prevent the sale, refinancing, or any changes to the title of the property while there's legal proceedings happening regarding the property. So in a wills variation claim, it is possible. So sort of the question that is also important to this is whether or not probate has been granted, because before probate is granted, it's a lot harder for the executor to do things to the property because it still exists in the name of the deceased and the executor doesn't have the rights to sort of do anything to the property yet. So wills variation claims don't necessarily prevent the executor from getting probate. So that means that it's probably wise to get a CPL on title if there is something going on with the property. And I'll just briefly go through how to file a CPL. So as I mentioned before, there must be proceedings occurring. So you would have to file a notice of civil claim with the court registry before you can file the CPL itself with the land title office. In the notice of civil claim, you have to make sure that you are claiming an interest in the land that you are seeking to put this CPL on. And that sort of connects you to the land as to why you want to prevent it from being sold or refinanced, etc. So for example, an interest in the land would be saying that you are entitled to a portion of the property or the net proceeds of the sale of the property. And then the CPL must also be filed with the registrar as well as the land title office, and you have 10 days to do so after the notice of civil claim is registered or is filed. And like I said, there's many different elements of this and a lot of steps to check. So to make sure that you are best protecting the property, it may be best to talk to a lawyer. And then this is especially the case if there's also someone who is challenging or seeking to have the CPL removed, because that happens as well.
Excellent. Thank you so much, Emily. And thank you, everybody, for your questions. They are really amazing. There's some great questions. So I'm going to move through some of the questions, and I've noticed some of them have been answered already. So I'm going to start with one that I think is a fairly quick response. Are stepchildren treated the same as natural children when dealing with estates in British Columbia as far as rights?
So children, stepchildren that are formally adopted do have the same rights as birth children. However, if you are not formally adopted, then you are not considered to be a child or spouse under the wills variation sort of section of things. So if you are adopted legally, then yes, you can bring a wills variation claim. But if you are not adopted legally, then you cannot bring a wills variation claim.
Excellent. Here's another question. How long do you have to file a probate, and what is the penalty for not filing?
I'll take this one. So to file to get probate from the court, not every estate requires probate. Probate is really a stamp of court approval that the will is the last will of the person. And it is what it really represents is that when you get probate, you can then take the will to the bank or to the land title office and say, look, here's a will that has been probated and I'm the executor, and I can transfer the property, or you can safely give the money to me. It's actually protection for the bank that if they see a grant of probate, then they can hand off the money. If you just go to the bank with a will and say, hey, I'm the executor, that bank should not give you the money. So having said that, there's a lot of estates where there might not be real estate, there might not be money in the bank necessarily, or just owned by the deceased, and so probate isn't mandatory. So there's no deadline necessarily. There's cases where probate can you might get it at a much later time, maybe even years later, just depending on the circumstances, really. Having said that, if the executor is being, is delaying and they should get probate, but they're not, there's a process called a citation that beneficiary can start where it essentially forces the executor to go get probate, or if they've been cited and they don't go get probate, then someone else can go get probate of the will, because it signals that they're just not going to go ahead with their obligations.
Excellent. Thank you, Aaron. Aaron, this question follows up on something you said earlier. To subpoena a will, does one file an application for a requisition or a petition in BC Supreme Court?
It's a requisition. So it's not a petition. It's a requisition, which looks like kind of a 1-2 page document. It's pretty straightforward. It's kind of boilerplate type of document. And the requisition for a subpoena does need to be supported with evidence. Evidence would be in the form of an affidavit. That affidavit is often simple. I'm not going to call it boilerplate, but it's often simple. The ones I've done are often from like a legal assistant or paralegal here, or maybe the client themselves saying, I know that X is the executor because whatever reason, because the deceased told me, or who knows what, and I sent them this letter asking for the will. They didn't respond. I sent them another letter asking for the will. They told me to go jump in a lake. So now I'm saying, so that's the affidavit. and then that requisition should hopefully lead to a issued subpoena from the court that you then need to go personally serve on that person to bring the testamentary document, the will, that is, to the court. And it
Excellent.
says if they don't, I believe the subpoena says if they don't, that they can be, I can't remember the exact wording used. I thought I had one before me, but they can be taken to prison. I mean, I don't think that's ever happened, but you know, that's what it says.
Okay. Excellent. Thank you so much, Aaron. Here's another question. Can an executor or joint executors turn over their duties to a lawyer if the duties are too onerous, or if a beneficiary is unwell mentally and causing challenges in the process of settling an estate?
Emily, do you want to take this or should I? Oh,
You can-
yeah. So you, if the estate is essentially, by the way, I just want to say I did pull up that subpoena and it does say failure to deliver the specified documents can result in your arrest and committal to prison. Unreal. But anyway, never seen that happen. You can try to step down as an executor if you've already taken steps as an executor. It's not going to be so simple, and you're going to actually need to go to court to get approval to step down. You'll want to be discharged. You'll have to present your accounts. You'll have to go through a passing of accounts, probably. You might be able to frame it in such a way so you can go through the passing of accounts after. But yes, you can step down as an executor. I think the question mentioned passing it on to a lawyer. It doesn't necessarily need to be a lawyer. You can pass it on to whoever is going to be willing to take on the burden. But there are options available to you to get out of it. But you know, if you're in the middle of it, those options might not be so straightforward.
Excellent. Thank you. And I think we have time for probably this one last question. Prior to interim distribution, the beneficiary will not consent to an informal accounting. What should the executors do? Also, prior to final distribution, the beneficiary will not consent or sign the release. What should the executor do in order to lessen the chance that the beneficiary may contest the executor fee and how the estate was handled by the executor?
So we discussed this a bit in the middle of the presentation, and really the most direct answer is you're going to have to pass your accounts in court. So beneficiaries won't sign a release, then your option is to go to court to get that passing, which is a stamp of approval from the court that your administration was proper. And also when you pass your accounts are going to include what your remuneration is. And so the court is passing that as well and approving that as well. And you're going to have to potentially present evidence of why you are entitled to the remuneration that you're claiming in the accounts. So that's really the option, is if you don't get a release, whether it's an interim distribution or a final distribution, go and get the accounts passed in court.
Excellent. Thank you. And I think I will just add one last question. It looks like a quick one. Is there a citation to move an estate along if probate is not needed because the estate is under $25,000?
I'm not aware of a citation to move the estate along necessarily. If you have an executor who just isn't moving forward, you can potentially you can bring an application to pass over. I keep using this because it's a legal term in the law, but it's not necessarily layperson's term. You can pass over them as executor, and so someone else can proceed. A application to pass over is very similar. In fact, it's the same as an application to remove, because you're essentially removing them as executor for whatever reason, delay, or just not complying with their obligations, like Emily was talking about earlier. So that would really be your option in that case. Because even in the citation to get probate, all that does is get them to get probate. It doesn't actually get them to do anything further. If they're just not acting, the executor, then getting them removed, even though that can be a complex application, might be your most practical option.
Super. Thank you so much, Aaron, and thank you so much, Emily. Thank you to everybody who submitted questions today. They were excellent questions. We're sorry we were not able to answer all of the questions. However, did respond to a number of them, and really grateful for you all joining us today, and to our speakers. I thought I might just ask our speakers a couple of wrap-up questions. Emily, it's been so great having you. Thank you so much for joining us here today. Is there anything that we didn't discuss in today's webinar, or any final thoughts that you'd like to share with our guests?
There is a lot of information available on the internet through People's Law School, through law firm blogs. Like I know, for example, Clark Wilson does a lot of blogging on common issues experienced by people. So if there is anything that you want to try to get information yourself, there is a wide variety of information on the internet.
Amazing. Thank you so much, Emily. Aaron, anything that you'd like to share with our guests before we wrap up today?
Yeah, a couple things. First of all, thank you so much to People's Law School. I think that what you do is really fantastic, useful, practical. And so I'm really honored to be able to help out with that initiative. In terms of the substance, these are all good questions. There's, a whole wide range of contentious estate issues that can come up that we deal with. Don't hesitate to contact a lawyer. It just, trying to deal with it yourself can sometimes lead to the issue becoming even more complicated. Emily and I make ourselves available to people that call, even for some quick guidance. We do have to do things like run a conflict check, but please feel free to reach out. We're both at the firm Clark Wilson, again, which is thankfully easy to spell. And you can find our information online. I think you can find it through People's Law School website as well. So just feel free to reach out, because we're happy to help. And even if you don't end up retaining us, we can give you some guidance to at least put you in the right direction, and maybe let you know how complex your issue might be. Maybe it is something that I tell people quite often that, this is something you might be able to just navigate on your own. But if it's something that I think, you should probably get a lawyer to help you out, at least to some extent, I'll be direct about that as well.
Thank you again for joining us. And thank you again to Aaron and to Emily. It's been amazing having you here, and we're really grateful for the work that you do. So thank you so much.
Thanks, Paula.